This is, we're going to be looking at whether the prediction of monetary penalties for data protection cases in a number of languages. So the motivating question is, well, is machine learning able to provide something more effective for data protection regulation? And for those who may not know about maybe the intricacies of data protection regulation, I have a very brief primer on what happens. So in 2 sentences, data protection creates obligations for the controllers of the data, and it creates rights for the data subjects. So if you hold data, you have certain things you must do. If it is your data that is being held, you have rights against it. And often in probably the most widespread model, which we'll kind of call maybe the European model, data subjects can complain to an external authority, which is empowered to take corrective action, including perhaps even penalties. And this is what we're going to be looking at. Data protection authorities have a few challenges. Now, the first challenge is that we are having increasing digitization of our society, for better, for worse, and that means that there are more instances where the Data Protection Authority needs to be investigating. This is difficult because as you get these increased complaints and needs for actions, it's difficult to assess where the authority might be able to best use its time to make effective use of the law and policy. And compounding this is a resource disparity between the authority and the controllers. This is true for any regulatory system. The regulator is always at a disadvantage. It is smaller, more constrained, it has less information, and that is regulated. And this is true in data protection. So looking at, can we, from a set of facts, wouldn't it be great if we could give a set of facts to the Data Protection Authority and they could determine whether maybe this could be a violation of data protection law, something that they might penalize. And for that, we're going to use our data set is from Macau. Macau is a special administered region in China, sort of less famous than its sibling, Hong Kong. See, it's a small little jurisdiction. It's a former Portuguese colony, and that has continuing influence on the public administration. Most notably here is that they use Portuguese in the legal language, and also that they adopt, and because they're a special administered region, they can kind of write their own laws. So they're not constrained by Chinese law in everything. And like I mentioned, it's modeled, so their data protection legislation is modeled on the European model. So we have a little bit of generalizability here at the end for our conclusions. So in Macau, the law is the Personal Data Protection Act. It's very similar to what you'll find in GDPR or the European's General Data Protection Regulation, and similar. It is overseen by the Office of the Personal Data Protection. The acronym is actually the Portuguese, which is, I'm not even going to pretend the person is going to make fun of me, Gabinete Protección de Data Pessoas, something like this. And it's currently inundated with a lot of cases. In the last year, it had just a shy under 3,000 cases. And that represented a 60% increase on the previous year. And when you consider that the Data Protection Authority there really gets through about 10 to 20 cases a year, that really puts it in perspective. There's a lot that's missing. And how do you prioritize this? And so maybe we can use some methods from the literature to see if this might help. This is just a quick overview of how it gets there. So kind of what I'm explaining. It comes in through one of these catalyst things. There's either complaint or referral report. They assess whether it should be carried forward. They then determine whether there's a violation of one of the 3 types. And there's different articles. The first lot is about data rights. The second is about data security and confidentiality. And the last one is about publication of methods. And if you do, you end up with a penalty. And the penalty is not so severe like GDPR. You can end up with I think it's like about $5,000 US. I think that's the highest it can go if you convert the money. So what do we do? Let's get into some of the experiment. So we collected just a little under 300 cases, 281 cases. And what we did was, what's very helpful about this data protection authority is that it provides each of their cases in 3 languages: Portuguese, Chinese, and English. But the English is unofficial. It's just more for what is useful for us. And we have, out of all of those, we have about 26% received a penalty, and the rest did not. And that's really useful because in other authorities, they only report on the cases they give a penalty. This one, they tell you whether or not. So we get a nice binary classification test. We focused on the case brief. So the cases have the brief, like what had happened, the facts of the case. They have the analysis, and then they have their judgment. Like I said, and there's no reference to law or policy in those briefs. So that's really good. It doesn't bias it in any way. And there's a little example for one of the cases, and that's just kind of how it kind of describes it. And you can see already the differences between the 3 language groups in terms of, maybe what our inputs into the different models are going to look like. English and Portuguese are quite similar in number of when you tokenize the corpus. You end up with very similar numbers. The Chinese corpus is a little bit different, and that actually has implications later on in the results. So it's our task, prediction of whether a case will receive a penalty or not. And we want to attempt to replicate real world circumstances. We utilize what's been used. So we're not really proposing any new methods here. We're just utilizing them in this pipeline. And we want to examine the differences in the languages. And we want to highlight maybe the limits between interpretability and explainability as it's useful in law. And so we take from previous literature where this has been used. We identified that SVM has been used a lot, naive Bayes, random forest. These are well-known methods. I know that there are now language models we didn't do. We wanted to see what a data protection authority could use, really relatively kind of off the shelf, without answering any kind of new questions. So we evaluate the performance of those 3 on the different texts. So we have our pre-processing, our feature extraction. This is a common model for the bag of words approach. Because of our small data set size, we use a 3-fold cross-validation, and we evaluate performance against common metrics. And then we explore explainability. So here is our table. You can go through a little bit more in the paper as you like. Highlighted obviously means that was the most performant. It's interesting that at least in F1 scores, there's quite similar for English and Portuguese, and that Chinese is a little bit less performant. And when we used the Lime methodology. So we ended up saying out of all of those, because Portuguese and Chinese SVM was quite good, why don't we just look at SVM? So we took one of the folds in the model, and this is just for a qualitative look. This is not to derive anything special. So we took which were cases that were the same, that they all classified the same as getting a penalty, and what were the predictive features. Now, because it's a bag of word approach, the kind of determinant features are a little bit nonsensical and in isolation. So it's interesting. So this case was about a photograph being used and published on a website, and somebody wanted it taken down. A company had been using it for promotion, and they got a penalty. So interesting, in Portuguese and English, photo is one of the biggest ones, but in Chinese, it's not. It's actually the first thing that's kind of positively putting to it is the term tao sao, which means to complain. And then the one after it is really an anonymization of the, it's E or Y in Cantonese, which means kind of an anonymization. So we don't really have a lot of great reasons why we have a determination this way or the other. And if you look at some of the other features that contributed, they're a little bit different in Portuguese and English as well. And they're completely different in the Chinese. The translations don't all match up. So when you have a multilingual jurisdiction, one, what would you use, particularly if you have two working languages? And whether or not this is useful for interpretability. So could you use these methods in data protection regulation? Well, actually, the previous discussion was kind of useful for it because, yeah, you may want to deviate from your, you are training on past decisions, but there may be factors that you will use that are different. There might be something that's that will qualitatively be different. And we would also argue that probably you might want to do this for case prioritization, but not necessarily for fully automated, full whack, putting through judgments, because you're not going to get sensible answers. And how can you appeal on the determination? You couldn't, because you're not going to get something that's meaningful in terms of an explanation. And some of the further questions that we had for our that was left a little bit open, but we discussed it a little bit more in paper. So what happens when regulatory priorities change? So you have your training data is one way, but your priorities may change as a regulator. You may want to focus on different aspects of the law, but your previous cases are decided in a certain way. Therefore, your system will now be less effective, and it already has pretty questionable performance already. And does a description of the factors amount to an explanation, and one that can be used in an appeal or to argue against? And yeah, in the bag of words model, no. We'd be interested in using other like language models and BERT and their derivatives, start looking at things like that to probably derive some more semantic, capturing more semantic meaning. So that's it. I think I'll draw it there. And like I said, you can look at the paper, you can email me some questions or complaints or whatever you like. Yeah, thank you very much.
Okay, thank you, Aaron. You stick to the time as a Britain used to do. Well, we have a question for you. I don't have the name of the person who made it.
It's okay. Quiz me.
But the question is, you mentioned in the article that the study is experimental and limited because of the data used. Are these data public? Can you increase your database to bring new results about your work?
So the data were scraped from the website of the authority. Yeah, the plan. If I haven't gotten around to making this data set public and the other one, I ought to. Yeah, and if you were to increase it, you'd have to just pull the data from the website again. They don't provide it as a matter of course. So there's a little bit of faffing about with like web scraping and pulling that data out of there. I hope that answers the question for our anonymous friend.
Just to clarify for me, to clarify the data protection system in China, there's a thing that I didn't understand. Macau has an independent authority, independent from the rest of China, right?
Yes. So it runs its own domestic affairs, if you like. It's very similar. They have a constitution that runs so they have their own data protection act, which is different from Chinese legislation, and it is adjudicated upon by the courts in Macau, not in Chinese courts.
Oh, interesting. Okay, and I see that you study data protection regulation also. Yeah, and I'd like to know if you have an opinion about if legislations like GDPR can somehow delay the development of business, of AI business, of the development of technological innovations. What's your opinion about this?
So actually, it's an interesting question, because in this, would even the data protection laws even come into it? And I'd argue probably not, because you're not processing really any personal data, personally identifiable data, unless if you're not naming anyone. And they often anonymize the cases in these. So, you know, in this case, well, you could use it, and because a lot of data protection, when they're talking about AI, it's like, well, you can't use the personal data, but these are not personal data. These are now previous data, but you're still having the same problems because it's going to produce a legal effect for you. Do these things, do they inhibit, well, the general creation of AI? I mean, that's quite a broader question. I would say briefly, probably in some way, because you have to do a lot with it, but also difficult because data subjects probably don't even know what they would be complaining about. It just feels wrong that someone's using our data to do things and make decisions about them. And that's really the harm. It's not the fact of using data, it's that you're getting decisions made about you, being categorized and classified in a way that's opaque to you, with no real way of explaining it.